Today we are going to talk about the state of suppressions, justice served or hidden. As Michael mentioned, we have a great lineup of people to talk to you today. But just a couple of things to set the scene. I think that we all accept that open justice is absolutely fundamental in a democratic society. Our Chief Justice Warren has made it very clear that is so important in this state of Victoria, as have many other judges. Justice McHugh in the High Court also years ago came out with a similar comment, but then observed that you read so many judgments and judges recommend that fundamental right to open justice and need for open justice, but then say but, and there is some reason why the proceedings should in fact be suppressed. The Victorian government, recognising that problem, brought out the Open Justice Act, Open Courts Act, and that has made it very clear that judges must start from a premise that proceedings should be open. But there's no doubt, even though we would like every single case to be open, there's no doubt that every accused has a right to a fair trial, and there are circumstances, the media would say limited circumstances, in which a suppression order is in fact justified. As I mentioned, we have a great panel. Michael's been through the panel and mentioned them. I'd just add a couple of things. We are very lucky to have Simon with us. Simon obviously being on our Court of Appeal. I suggested to him before, being a sitting judge, he might be limited in what he could say, and he said not at all. So that's very pleasing to hear. I think Simon's in the unique position that he's one of the few judges that's actually seen life from both sides. He actually has seen how the media operates and probably, hopefully, has a far better understanding of the media than most judges. He was obviously a could-have-been, an original could-have-been, was known as Digger and the Massive from Moorabbin and Ivan from Ivanhoe. Simon actually was the sitting judge that sentenced Tony Mockbell to cool his heels for some 22 years. So he might have been interested to see a report in The Age today that Tony Modafferi is actually seeking an order for disclosure of sources against Fairfax. And also yesterday, Mick Gatto threatened to sue The Age. So some interesting issues, I think, for the future. Also, Philip, we are very lucky to have. Philip, as Michael mentioned, was on the Supreme Court bench for 20 years. He actually surprisingly heard a surprising number of media-related issues, and there's a whole range of judgments from Philip where he recognised the right of the public to know and is a great, I think, advocate of open justice. Michael is now looking after the investigative team at The Age. He's just returned from 3 years with Fairfax in Jakarta. He's a obviously Walkley winner and a very distinguished journalist in this town. So I'll now turn over to Philip to say a few words of introduction. We'll hear from our other speakers and then we'll go to a question answer. Thank you.
Thank you, Peter. In my 20 plus years as a judge, I always worked respectfully and cooperatively with the media, and I always trusted them. And in my 20 years, I was let down not once. So I congratulate the media, and I'm very pleased to be here. In the gendered language of the 19th century, Jeremy Bentham wrote this on our hearts: publicity is the very soul of justice. It keeps the judge himself while trying under trial. And I think that is the centrepiece of any consideration of open courts. And paradoxically, when courts are closed to protect the administration of justice, I think that inherently undermines justice rather than promotes it. There are plainly some circumstances where, as the legislation recognises, courts need to be the subject of issuing suppression orders, some interconnected trials, physical safety of persons, some terrorism trials, although I think we need to be careful that the word terrorism does not lead to a reduction of the very democracy we are seeking to maintain. And there are, of course, some statutory prohibitions on publication, as you are all aware. I would, however, make a plea for trusting juries. I've seen juries over many years. I've seen how hard they work. I've seen how conscientious they are. I've seen how responsible they are. I've seen how fair they are. And I've seen how decent they are. And I think we all, including the bench, should put a lot more trust in juries. I think they are robust. And I think a lot of orders don't recognise that robustness. But the fact that you look at the results of cases of highly notorious people where there are acquittals on some counts and convictions on others, or acquittals altogether, I think demonstrates as a track record juries can and I think should be trusted. We consider whether the courts have overshot the mark on suppression orders, and other speakers today know much more about this than me, particularly His Honour. I think there are some reasons why courts can overshoot the mark. Plainly, not having enough confidence in juries is one. I think there can be a slippage between the test of necessity, which must be the test, into considerations of being prophylactic, being therapeutic, just being cautious, which is not the test and should never be the test. And I think also there is a tendency of courts to move carefully from example to example and accretion to accretion, like the barrier reef. And I think we have to be very conscious that we don't build up a body of law of excluding the public from case to individual case. So I very much look forward to our speakers telling us whether we have gone too far and what we should do about it.
Excellent. Thank you. Michael.
Thank you, Philip. A year ago, when I was in Indonesia, the habit of Australian courts of making suppression orders made big news overseas. I can't tell you the names of the people I'm about to talk about because they are still suppressed in Australia, even though they've been widely published around the world on the internet. Suffice to say, one particular figure was a global leader whose name was suppressed in the Security case to protect him and Australia's national interest from embarrassment. Then WikiLeaks threw a spanner in the works, revealing this man's name by publishing the suppression order in its entirety. So, of course, the global leader, who already had a prickly relationship with Australia, wanted to know why his name was being used but covered up in an Australian courtroom in a corruption case. He tweeted his puzzlement, as you do these days, saying, and I quote, "The government of Australia should be completely open and make transparent its law enforcement process and not cover it up." I'm here to endorse that sentiment. It's a sentiment actually that's already endorsed by the common law. It's been endorsed again by the Open Courts Act of 2013, but in Victoria particularly, it's too often ignored. And from the vantage point of Indonesia, where virtually everything, including the corruption, is conducted openly, the suppression order looked rather ridiculous. This was increasingly the case as the story rocketed around the internet in jurisdictions that were untouched by the machinations of an Australian courtroom. And the puzzlement about this case only increased when the Australian Embassy put out a statement in response to the tweet of this world leader that I cannot name, saying, quote, "The government stresses that the Indonesian president and former president are not the subject of the security proceedings." The release went on to say, "The suppression orders remain the best means for protecting the senior political figures from the risk of unwarranted innuendo." I disagree. In my view, the best way to protect them from unwarranted innuendo was to conduct the case in the open, so that everyone could see the facts and the arguments one way and the other. And it's particularly galling in the security case that such a wide suppression order should be issued, because that case only exists because of the operations of investigative journalism, particularly my estimable pals and colleagues Richard Baker and Nick Mackenzie. It's easy to find other examples of silly suppression orders. Justin Bosland of Melbourne University unearthed one from the Magistrates Court that prohibited, quote, "the publication of any reference to X, the defendant, or Y, a well-known AFL football club." No doubt the order was breached about 40 or 50 times a day for its entire 4-month duration. Courts are places where embarrassing things are aired, but I believe it's in the interest not just of journalists, but of members of the public, of defendants themselves, of judges and prosecutors, that they be as open as it's possible to make them. Even without suppression orders, the reporting of court cases is already inhibited by more than a dozen pieces of legislation, by the sub judice principle, by the secrecy provisions within national security legislation, by a number of courts and tribunals who are able to hold closed and in some cases coercive hearings. The new metadata legislation, for example, appoints a court officer to protect the rights of journalists, even though the journalists themselves are not allowed to know what's being argued on their behalf, or even that they're involved in a proceeding at all. I concede, as would most journalists, that some things should not be reported, and the clearest example being the names of sexual abuse victims and rape victims, but I'm not convinced that the names of the perpetrators should be suppressed as well, which is often the case now. So, from the vantage of journalism, both governments and the courts seem increasingly unwilling to have their operations open to public scrutiny. It was really good to hear earlier about the situation in the US. We've become used to a situation where government people and functions, bureaucrats and so on won't even return our calls, much less answer our questions. Whereas that would seem untenable in the US. I think there is an exaggerated belief in the delicacy of juries, which means that facts can't be presented before a jury comes to deliberate on it, in case it sort of poisons the minds of juries. I think that's an exaggerated fear. And the problem is that that this kind of attitude and the kind of habit we've seen in courts is emboldening legal counsel, to make applications for suppression orders in ever wider circumstances. I recently sat in on a preliminary hearing in the case of Sean Price, a man who's accused of murdering Masa Vukotic. Seeking a suppression order over even these very preliminary proceedings, likely a year or so away from the trial, his counsel cited the emotive nature of the case as one of her reasons. She said, "The nature of the murder allegation is so highly emotive and has already struck an emotional chord," pointing out that there have been rallies and protests organised. So, in essence, for that part of her argument, the lawyer was saying that because the public was so interested in this case, the public was not allowed to hear about it. Imagine what it's like as a journalist hearing that kind of reasoning. The magistrate took 2 days to think about it, but then he sensibly rejected the application, but other judges and magistrates have not. I'd say to that lawyer, and to the courts in general, that in the long run, the interests of her client and the interests of defendants in general are best served not by secrecy, not by conducting proceedings behind closed doors, but by the courts operating openly under the public gaze with a sceptical media looking on. That's long been the principle. It's too often been abrogated, particularly in Victoria in the current era, but it's a good one and we should be adhering to it.
Simon.
Well, I agree. Phil sent me a note of what he planned to say, and I said to him when he arrived, "Phil, I agree with everything you said. It's not going to be much controversy." But I'm now adding the but.
Right.
First of all, if I could just mention a couple of things. The Open Courts Act really made provisions which reflected what the common law had been before anyway. Whilst it was hoped that it would lead to a situation where there were fewer suppression orders, that's not been the experience. In Victoria, suppression orders are collated and entered into a database in a 100% comprehensive manner, which I don't believe is done in any other state. It's done that way by the Supreme Court, which, without any funding for it or any statutory obligation to do it, has simply done it because it's in the interests of justice and certainly in the interests of the media, I would have thought, that that be done.
And if I can interrupt, I might say Anne Stanford's here and she does a fantastic job at the Supreme Court, as do the other people in the other courts, and the media and media lawyers are sent a copy of every suppression order in this state, which simply does not happen in the other states.
But part of the problem, or not problem, part of the one consequence of that has been that in Victoria we know exactly how many orders we make.
True.
And I have to say, over the last couple of years, the numbers have not gone down as we hoped they might when the Open Courts Act came in. The quality of the orders has definitely gone up, although Peter showed me some examples whilst we were having lunch, which I was disappointed to see, that shows some of the old forms of very broad orders with no sunset provision apparently are still happening. But I would have thought they'd be very much the exception rather than the rule these days. So the Open Courts Act hasn't altered the numbers. We've tried to compare ourselves with other states. We can get reliable figures from the New South Wales Supreme Court. The Victorian Supreme Court makes about the same number of orders as they do. We don't get reliable figures from anywhere else, particularly the District Court in New South Wales, other than from South Australia, and on a per head of population basis, they seem to make more orders than we do. But all of that is by the by. We really want to have a situation where there are very few orders, and I would venture to suggest, I don't think it's a secret, that I, like Phil, am of the view that we could have less than we do. There is a problem about orders being made in relation to matters that are already addressed either by legislation or the sub judice rule anyway. And there is a problem which permeates public administration generally, particularly in the area of law and order, of defensiveness and caution, and that can be an issue as well in this area. Now, mentioning security, I can't let it go by without giving the other side of the coin, not to contradict what's been said, but rather to make a different point, which addresses a different aspect of that issue. On about the 4th of August, I think it was, there was something of a media controversy about that order. There was a very high-spirited radio performance by the editor of the Herald Sun, and a similarly high-spirited media watch about an extraordinary position which they had just come to their attention, incredibly. In fact, Media Watch opened up on the 4th of August with, just Wednesday of last week, it was revealed. And what was revealed? This shocking order had been made. Well, what a terrible state of affairs that it had only just been revealed, and only by WikiLeaks, publishing it on the internet. So what a scandal. What judges were involved with that? How could this have happened? Well, what had happened was that on the 13th of June, close enough to 2 months before then, 90 media organisations had been sent, 90 emails were sent by Anne Stanford to every media organisation, certainly in Victoria, and would have covered all of Australia, telling them that the Department of Foreign Affairs and Trade was making an application in the security proceeding for orders that the names of certain people not be published because it would damage Australia's foreign relations. I wonder what that could have been about. Who would have guessed that an order might be made prohibiting the names of people? On the 19th of June, the application was heard. No journalist lawyers came. No journalists came at all. The order was made unopposed by the Department of Foreign Affairs and Trade's application. 90 copies of it were then sent to every media organisation in Victoria and covering Australia as well. 8 were sent to the ABC. 8. 7 were sent to the Herald Sun or News Limited, and 1 was sent to Justin Quill. How is it then that the editor and Media Watch were astounded to discover this order on the 4th of August, when they had 8 copies in their office on the 19th of June? I understand why it's said that that order was not wise, and there have been submissions made about that, and there have been rulings and so on. I'm not entering into that. But if you want to know why sometimes judges get irritated, there's an example which we find annoying, to be criticised for keeping something secret when it's been in their office for 6 weeks. Now, what else was I going to say?
Just remember, you are not being controversial.
Philip's point about juries is very well made, but can I just add one caveat? The caveat is prior convictions. Juries don't hear about prior convictions. I think, as Phil does, juries are well capable of separating what they've read in the paper about an offence from the evidence they hear in the trial. In fact, the trial process overwhelms everything you've heard before. You learn so much more about it that I suspect that in almost all cases, what Phil says is true, that the jury does decide the case on the evidence they hear in the courtroom. But they won't hear anything about prior convictions. Prior convictions are very prejudicial. If they know about them, the defence can't deal with it in the case, and it can have a significant effect. And I feel, perhaps rightly or wrongly, that the inhibitions that the press once felt in terms of sub judice in revealing prior convictions, particularly of certain kinds of offenders, has reduced, and that that is a potential significant problem for jury trials. But we'll have to see.
Well, Your Honour, I used to think what you've just said, that prior convictions should not be published, and I'm still half of that view, but I'm not altogether sure we can just say as an a priori statement they are highly prejudicial. I've had a couple of trials where the jury was told the prior convictions for reasons which I won't trouble you with, and the jury in both cases were so careful and so assiduous. I think juries, and I'm not recommending that prior convictions should be introduced, but I'm just saying I don't think we can just assert it a priori. I think juries, even there, and that is a hazardous ask, I acknowledge that, even there I think juries would show responsibility. And it's rather an Australian thing. You lean over backwards to be fair. And I think that will operate in juries' minds if the law was changed on that. And I'm not recommending it's changed. I'm just saying I'm not sure that we're quite right in our credo.
We might now invite any questions from anyone in the room, but I just wouldn't mind a little further discussion on the security matter. I think the area I found controversial in that order, and sounds absolutely correct in saying the media was given notice that an application would be made for a suppression order. But I saw that personally, that notice. But then I was shocked when I actually saw the order once it had been made, because I didn't realise there were such sexy names on that on that order. And I looked at it and thought, gee, the media would be very interested in publishing this. But I think it raises a very interesting issue, because WikiLeaks, as Michael mentioned, then totally breached the order and in an outrageous way put it online. But of course, WikiLeaks is outside the jurisdiction of the Victorian court. And so the media recently went back to the judge and said, well, now it's up there. It's on a lot of other online sites. A lot of traditional media in Asia have also breached the order. And so it should be lifted here. And in reality, the judge has ordered that it be lifted, but it's still covered until, I think, 14 July to give the Commonwealth time to decide whether it appeals. But it does raise an interesting issue, I think, for our panel on the effectiveness of an order, a suppression order, in this day and age where we're in the online environment and the court has jurisdiction now under the Open Courts Act. It can make an order to cover the whole of Australia, but clearly it can't cover those online sites outside Australia. Have we got any comments on that?
Peter, I'd also add to that it doesn't even cover the online sites in Australia, and that very often the things that we can't say, being responsible media organisations with assets and capable of being sued and taken for contempt and so on, are being said within Australia on websites all the time.
Well, it was in fact that footballer in the UK, there was a suppression order or an injunction, and I think there was something like 500,000 tweets that then totally breached the suppression order. And of course, number one, you can't necessarily identify who sent out all of those tweets, but it's beyond the ability of a court to prosecute 500,000 tweets. So it is a difficult issue with modern technology.
Yes, I think in the future, at some point, we'll have to address the issue of the way trials are run, and we may have to confront the situation, as Phil's foreshadowing, where we assume everything is known, and we need to construct a trial system which can cope with that. I don't think we're at that point, but it may be that we will be there one day in the foreseeable future, perhaps.
If I can say two things about health, I think that it is much healthier to have a court system that actually faces reality and deals with it by giving directions to a jury than by proceeding ostrich-like and not acknowledging the reality that is going to become more and more clear with electronic developments. And the other bit of health is in relation to security generally. I think it is not healthy to defend our freedoms by abolishing them.
I mentioned in opening that Simon was in the rare position of seeing both sides from the position of the courts and also the position of the media. Of course, the other person in this room who is in a similar position is Darren Hinch.
Thank you, man of many convictions. I've got two questions. One, obviously, there are times when suppression orders must be enforced, and that is when it identifies a victim. I agree with that 100%. But why can't we have that suppression order altered, that the name of the perpetrator is revealed, but you suppress, as judges, suppress the relationship with the victim and the age of the victim? In the United States, they'll say he was guilty of sexual offences involving a 13-year-old child. It doesn't say it was his niece, doesn't say it was his daughter. That was question number one. Number two, I'd like a general comment on Megan's Law. I mean, we've got 155,000 people sign my petition. It's meant to be coming in the Northern Territory this year. It's been opposed elsewhere. I'd just like your general ideas about why you would be, if you are opposed, to a public national register of convicted sex offenders.
Well, I can't buy into that, Darren. That's a political issue. Now, what was the first one again? Yeah, look, I can't see why that couldn't be done. I think you're probably right that not enough if more careful attention was given to what really needs to be suppressed, and you're thinking there of the Judicial Proceedings Reports Act about victims of sexual abuse, yes, I think less could be suppressed than typically is, because, of course, where you have a case involving incest, for instance, the tendency is to not identify the offender because it's thought that identifying the offender will automatically identify the victims. I would have thought in most of those cases that position could be addressed without the need to necessarily suppress the name of the offender. But
you got John Smith, who guilty of a sexual offence against a 12-year on a child under 13.
Yeah,
The victim
yeah,
might be
yeah.
4 or 8 or 10, and daughter, niece, or pupil, whatever. You can still name that person and not the victim.
This really gives rise to another issue which is significant, I think, that it requires some ingenuity. It requires someone to take the time and trouble to apply their mind to it and to consider how it would work in that case, to address the DPP as to how they feel about it, the defence and so on. Once upon a time, the media did that sort of thing in suppression order cases, and I remember both as a judge in my early days and when I was at the bar that was very commonly done. But nowadays it never ever happens. The media never appear in suppression order proceedings anymore, or so rarely that it hardly counts. In the Security one they did, but only to set aside the order. They didn't appear when the application was made by the Department of Foreign Affairs and Trade. I think that's a problem. The absence of a contradictor is a real issue because the defence and the prosecution often have a joint interest in secrecy because they want the trial to run without problems. They want the trial to go ahead without difficulties.
But that really is an issue for the future, I think, because in the past the media had the rivers of gold, which then there were large legal budgets to allow lawyers to go up there and challenge some of these applications for suppression orders. But those rivers of gold have gone. And so is that a real problem going forward, that you're not going to see the media in court as often challenging these suppression orders?
Well, I think it is a real problem because unopposed applications are usually successful. The Department of Foreign Affairs and Trade comes along with no opponent, masses of material. Who can blame the judge for accepting what is put before her or him?
Well, I think
the Chief Justice has done one thing, if I could just give her a plug, which is always a good idea. The Chief Justice has approached the Victorian Bar pro bono scheme to ask whether they would be interested in providing counsel to oppose suppression orders as a general proposition, to take up the role that once upon a time media lawyers did occupy. And I think that's a very significant or potentially significant initiative, which I think is a very good idea. Phil.
I commend the Chief Justice, as does Simon, for that initiative. I think it's a very valuable one. But at the end of the day, whether the rivers of gold are flowing or not, it's the judge's responsibility to get it right. And judges are used to looking at things from both sides. And I think that whether it's opposed or not, and assuming it's not, the judge still has the duty to consider these fundamental principles.
Seeing we're talking about the Chief Justice, the Chief Justice, I think, wrote the main judgment of the Court of Appeal in the Mockbell issue. And there the judge had ordered the Herald Sun, the Australian and the Age to take down all historical articles on Mockbell pending his trial. We appealed that on the basis it was a totally, utterly useless order because obviously the Age, the Herald Sun and the Australian complied with the court order and took down all of their historical articles. But there were still hundreds of thousands of articles still online from online publishers outside the jurisdiction of the court. And the Chief Justice in her main judgment came out and linked it to a local council library. And she said that where a suppression order has been made, it's never been expected that people would go into a local government library and somehow take that new hard copy newspaper out of circulation. And I think it makes a very important point that, again, the court needs to make effective orders, and the Court of Appeal in Mockbell and the New South Wales Court of Appeal in Ibrahim both decided that the court should not make orders that were ineffective. We have a question. Oh, any comments?
Look, I was just going to say, in this environment where the plethora of internet publishing is available, that actually mainstream media, much as we are hated by the plethora of internet publishers, is the best friend the courts have, because we are responsible to the court and to the law and so on to publish things that are fair and accurate, and very often the reports that are made about those cases by others are taken from the facts or the spin, if you like, that's laid out by the mainstream media and then amplified. But in the absence of that kind of reporting, it's a complete free-for-all, both in terms of facts and spin in the online environment. So I would think that having responsible and accurate reports coming directly out of the courts is something that the courts should be very much in favour of.
Good.
Hello?
I didn't actually ask Darren to identify himself, but anyone asking a question, if you could identify yourself, please.
Yes, Ray Beattie, and I write for the Herald Sun. I'm intrigued by the position of WikiLeaks, because on the one hand, it is vilified by the authority and attacked and so on. On the other hand, it is I think now has become a necessary source of information, and I don't think anybody in this room would hesitate to grab a piece of information out of WikiLeaks if it fitted into the story that they're writing at that particular minute. And we can see with things like the Pacific Partnership agreements and so on, where the only way the public had any idea what was going on was by the stuff that was coming out of WikiLeaks. And we in fact, the whole media depended on that as a source of information, because the bloody government wouldn't give us any. So the question is, what is the position of WikiLeaks, and will Assange ever be released?
No comment.
Look, I would just say on WikiLeaks, WikiLeaks is a form of systematic and secretive leaking, and journalists have relied on leaks, authorised and unauthorised, from contacts for as long as there's been journalism. So I commend it.
It was very controversial when Assange was actually given the leading award by the Walkley Awards as to whether he was actually a journalist, or some would use other descriptions. But it was certainly very controversial.
Dermot O'Brien. Simon, you obviously have a strong position on prior convictions, but isn't the problem with your position that you can do little about somebody's notoriety or infamy when it comes to a trial? What's your position on that, or what's your comment on that?
Well, that is true. And some people are so notorious that, yes, you can't. They do go to trial with the jury presumably knowing something about them. I think it does make a difference if they don't necessarily know all the details, and you'd be surprised how ignorant people often are about people we imagine are quite notorious. As Phil pointed out, some of those people have gone to trial making a virtue of their notoriety. They've, in fact, one successful acquittal was largely based on the proposition, it's because of who I am that I'm sitting where I am, and the police come to me because of who I am, and I'm prepared to say I'm this kind of person, but I'm not that kind of person. Well, that was a successful argument in one case, and somebody else also tried it. Yes, notoriety's always a problem, and there's not much can be done about that, I agree. But for your run-of-the-mill person being tried in the county court on some relatively serious offence, the publication of their prior convictions, and I think, as pointed out, the mainstream media are probably not the most significant source of this potential problem, but rather other kinds of websites. it has a significant effect. It has an effect on me. When I was hearing an appeal about a punch-up somewhere, and the defence basically was, it wasn't me, it was my mate who did it. And I looked at his prior convictions, and your attitude changes. It does. You look and you think, he's done this before. It's not the mate, it's him. I don't think... I think that's going to be a very difficult problem to grapple with. I didn't have to make the decision about guilt or guilty or not in that case, because it was an appeal, but I think if juries if it were possible to have open access to prior convictions, it would alter the way juries went about deciding things. Now, Phil might be right in the future that we're just going to have to address it because it'll be impossible to keep the genie in the bottle, so to speak, but we'll just... At the moment, I don't think that's the position.
Well, I'm not advocating it, Simon, as you know, but I do think we ought to look at it, and I think we shouldn't be overconfident that it would prejudice people. I think you are absolutely right that knowing prior convictions has an effect, but I think the real question is the second order question. Given that it has an effect, can you deal with that effect? And you deal with the effects of these things all the time. Juries are directed how to deal with things. Juries have an instinct for fairness. And I think that the real question is, can it be dealt with? And I think we ought to have a good look at whether it can be.
Another controversial suppression order, I think, is the one that was made in relation to Adrian Bailey. He obviously was found guilty of murder and then was facing 3 rape charges. And the judge made a blanket order that Adrian Bailey, the name, and Jill Maher, the name, could never be mentioned in the media pending these trials. Well, that's all very well and good, but anyone writing against violence against women is going to want to mention those names. And there were, I think, 6 or 8 or 10 breaches of that order, totally inadvertent. No one breached those orders intentionally. And most of the orders were made in feature articles on page 25 or something. But each time there was a breach, the judge referred the breach to the police for investigation and prosecution. And that judge, although she did the right thing in making that suppression order, arguably, was really trying to stop a waterfall. And you can't stop a waterfall.
Well, I won't make any comment on that case, but I think the courts have to be conscious of not being only court-centric. There are often, as you've rightly said, Michael, issues in the community which will continue to be and should be debated, and a court shouldn't stop that.
Okay, question.
Barry Donovan, Melbourne Press Club, following up on something that Michael referred to, and that is in the area of defamation. There are very clear laws, and have been very clear laws for many, many years, defamation relating to major media, newspapers, television, radio. So the defamation laws are very clear, they're black and white. If any of those institutions do something wrong or one of their staff, then it's into the court. Now, what I'm interested in getting an opinion from the panel is the fact that we now have this enormous spread of social media, and there are comments being made probably 100 times a day, often about public figures, and a lot of comments are being made which, if they were run on the front page of the Age, they'd be in the court the next morning. What I'm interested to get from the panel is that we obviously have no set defamation laws that relate to social media. People seem to be able to say anything they like about anybody. And what this leads to is I keep wondering now, when will there have to be a big classic defamation case on social media, on a comment made in the social media, and at some stage will either a judge or a major court have to make a definitive statement about what is defamation in social media. Are we going to get to that stage?
Well, it was interesting, even last week in the hockey case, the federal court judge said that a defamatory tweet was worth $40,000, which is a heck of a lot of money for a few words.
I was going to refer to that case as well. It's the obvious answer. That social media is already throwing up defamation cases, but only, it seems so far, when it comes to what mainstream media organisations are doing. And The Age lost $80,000, or will if we don't appeal. I'm not sure what we're up to on that, over 2 tweets. The tweets had the words "treasurer for sale" in them, and they had a link to the story. Now, the judge in the case of the story generally said, same headline, "treasurer for sale," but the story itself contextualised that headline, and therefore it was not defamatory. In the case of the tweets, because...
Which was a plus for the pre-publication lawyers.
Quite right. Dodged a bullet there, Peter. But in the tweet, it was assumed that a proportion of the followers, or a proportion of the people who had read that tweet would never have clicked through to the story to see the context, and therefore it was in those perhaps tens of thousands of people, said the judge, that the defamation lay, because all they had was the headline. He also gave a larger award, $120,000 for the poster, on the assumption, untested, that some millions of people may have seen the poster as they drove past the newsagent on the morning of publication. I would have thought there's a bunch of eminently appellable questions in that, but the point is that social media is already throwing up defamation cases, but just like defamation has always been, it's only ever taken against institutions that have assets and not against individuals. So all of that flammery you see on Twitter, of which I'm a proud and regular contributor, is never going to throw up a defamation case, because there's too much of it, and you won't be able to pin down the individual.
Where we're talking about tweets, a separate issue is it's now reasonably common for reporters to tweet from court or file a story from court. And what's the position where a tweet is tweeted, if that's a word, or an online story is filed, and then the judge makes a suppression order?
Well, it's too late. And we have to be conscious of that, especially now under the new Court Securities Act, where journalists can use the electronic equipment in court unless... I mean, that's the default position now, unless there's a direction made stopping that. But, yeah, you've got to do something about it before you say it, not after, which used to be the position. Yeah, at the end of the day, the counsel would get up and say, by the way, everything said today. But I think judges are pretty conscious of that, or they ought to be. Once it's said, and nowadays it can be out in the public 1 second after it's been said.
Good. Darren?
I have one more question. I think there's an elephant that is sort of still in the room here. And today's talk is about suppression orders. And the elephant is still the internet, because it is something I don't think our legal system has even got its head anywhere near around. I named Rolf Harris months before the other media did in Australia. It was supposedly suppressed in England. Now, I get around it by putting at the top of my blog on these days it's needed, and I'll say, access to this editorial illegal in Victoria. And so you're the criminal if you open it and read it. So far it's worked, but it's pretty thin ground, I'll grant. So what's your reaction? I mean, where are we going to go? Because you cannot, you called it a waterfall, you cannot stop it, and I don't know that the courts have got their heads around it at all.
Well, The Age, actually, when it published front page the Rolf Harris story, put a note on the front, a box on the front page saying, don't put this article online, don't tweet it or anything else, because you will be in breach of the suppression order in London.
But that was 4 months after he'd been named in London. He'd been in court in London.
Yeah.
Yes. Well, look, we are certainly aware of it, which is why the Mockbell order was not upheld on appeal, and which is why Justice Hollingworth, subject to an appeal which might be brought next week, had revoked the security order. Once something's known, well, it's known. You can't unknow it. And it's also why I postulate that in the future, we're going to have to address running trials where everything is known, because it won't be practical or realistic to proceed in any other way. I still think that's in the future. There's still a very important distinction, though, Darren, between information which is thrust before potential jurors and information which people have to search for. Information you have to search for is not a great problem, really, because if you're motivated to search, or those who are motivated to search are rare. When jury panels come, they're told, if you know something about the case, if you've already got a view about it, identify that, and we ask them what they know and so on and decide whether they can be on the panel or not. That's not such a great problem, and that was pointed out in Mockbell, that the fact that there are stories there which, if you search for them, you can find them, is not as significant as having things on the Herald Sun website or the Age website where anyone who looks is going to get it, whether they're looking for it or not. So there's still that distinction. But I think you're right, Darren, in the future, we're going to have to address the fact that probably everything's going to be known. But I don't think we're there yet.
There's another issue, I think, of in relation to suppression orders. I mentioned that in Victoria we have a great system where we see every suppression order that's ordered. But a problem with a lot of criminal cases is that there's a pseudonym. And it is totally unhelpful to send to the media or to send to the media lawyers a suppression order with the defendant being ABC or something. That's a real problem. With Carl Williams, for example, he had two pseudonyms. I think one of them was Witness N and one of them was something else. And unless you were the court reporter who was up there and actually knew who Witness N was, you're at a great disadvantage, and therefore there's a significant risk that the media could inadvertently breach that suppression order. So it would be good if we could find a way for the media to somehow be told who that person is, but knowing that they can't publish that name.
Ring Anne.
Well, I've done that sometimes, and sometimes Anne doesn't know.
We're conscious of that. It is a problem, and Anne is very conscious of it and is always thinking of how to address it.
Yeah. Mark. Oh, I think we're being wound up. This is not good. So I think we call on our president to wind things up. But thank you very much indeed.